The fact that the FBI and the local police lost the guy for 15 hours thinking that he's a murderer scares the shit out of me.
Welcome to the global phenomenon, Surviving the Survivor, where we're all just trying to survive in a rough world.
What's up, STS Nation, and welcome to another episode of Surviving the Survivor, the podcast that promises to bring you the best guests in all of true crime. Now, this week, revelations that law enforcement lost Bryan Kohberger for a time. How long that was, we're still not sure, while he was under surveillance. As you know, I like to start by remembering the victims in this crime, so let us never forget those young lives lost way too soon. Madison Mogen, 21, Kaylee Goncalves, 21, Xana Kernodle, 20, and Ethan Chapin, 20. May their memories be a blessing. Now, police say the killer is 28-year-old Bryan Christopher Kohberger. We want to remind everyone, especially since we have a retired attorney and a current attorney, that Bryan Kohberger is presumed innocent until proven guilty in a court of law. Our best guests break down the very latest. We welcome back to the show Idahoan Jessica Bublitz. She is a skilled litigator with more than 20 years of courtroom litigation experience. She's tried numerous cases in both state and federal courts. She is the first woman in Idaho to be named a top 100 trial lawyer by the National Trial Lawyers. She's also a graduate of Idaho College of Law in Moscow, Idaho, so she knows the area very well. The new face to the program, who hopefully will be here more than just this one time, is an attorney, retired now, and civil justice advocate, author Mark M. Bello. He draws upon 40 years of courtroom experience in his Zachary Blake legal thriller series. You heard it right. He went from lawyer to crime and legal thriller author, and he has pumped out a gazillion books in a short amount of time. I'm trying to write just one and can't seem to get it done. He is a Michigan native. He has a degree in English lit, like yours truly, but he uses his. And he's also host of the Justice Counts podcast. Check it out, Justice Counts. Now, before we get started, some housekeeping notes. You can follow us on Instagram, Facebook, Twitter. We are at Podcast STS. You can also find us anywhere you listen to podcasts. Please support us at Patreon, or you can subscribe on YouTube. And as my 8-year-old daughter says, please hit that like button. It gets the algorithm chugging. So first off, thanks to both of you. There is actually a decent amount of news as it relates to the quadruple homicides in Idaho. First, coming from Ethan Chapin's mother, Stacy Chapin, who actually spoke out not too long after the quadruple murders and is now back, this time on Facebook. She, on a Facebook post, is speaking about the small victories that her family accomplishes each day in the healing process. She has revealed that she and her husband visited, this is so hard to imagine, their two surviving triplets, Maisie and Hunter, at the college where all three had been enrolled before Ethan's murder. Ethan is one of three, a triplet. Jessica, I'm not sure if you're a mother or not, but does it break your heart the way it does mine to hear that Stacy Chapin is trying to pick up these pieces, and it's got to be super difficult?
Absolutely. And I am a mother. My daughter actually attends University of Idaho currently, was in the same sorority Alpha Phi as Kaylee Goncalves, same age. So I am familiar with, what parent I am, what a parent of a student who's been going through this. And her strength is just amazing. I think she's just the example that she's setting for someone going through trauma, for her children to be strong and to go back to school in the same environment and make normal out of it as much as they can, I think is so admirable, because when you go through a trauma, the school itself has gone through a trauma, right? And when the school goes through a trauma like this, although they are in the process of recovering and rebuilding their lives and doing things that they were doing before, going back to class, things that they were always doing, it's always a little different, right, after a trauma. But I think it is good to go back and to send that message to her kids that it will go on, and that they are going to be strong and they're going to get through everything, and that they're going to still have a college experience, and that they're still going to go to class, get their degree in honor of their brother, of course, and just move through it as best they can. So I just admire her so much. And I know, not all the students made that decision even to go back. And some of them decided that University of Idaho wasn't going to be for them for a little while. Some of them just decided that they'd rather stay home. And some of them went back. Most of them did go back. And I think that, to have her experience, to be speaking out like that is just incredible that she's doing that.
And Mark, you're the accomplished author on the panel here. She really describes it beautifully on her Facebook post. She writes, "The start of the grieving process felt like standing at the bottom of the wall with no key to get through the gate and no rope to get up the wall. The rope has been tossed over the wall and we've started the tedious climb." Eloquently stated. I know you have almost as many grandchildren as books. You got a lot. Your father. Does it hit home knowing she's got triplets and has lost one of them to such a heinous crime?
Well, it absolutely hits home. The closest I can come to anything like this is watching my 18-year-old nephew die of cancer. It's pretty awful, and it's affected the lives of all of my family members, especially my sister, who is the mother of the child. He's now been gone just about as long as he was alive. And here we are 18 years later, and it's like it was yesterday. So to have something happen like this, where it's trauma and there's no time to prepare, and on top of it, we have some multiple births in our family, and losing a triplet is like losing a piece of yourself for the surviving triplets. It's not describable for somebody who hasn't experienced it. This is just awful. I'm looking at, as we're speaking, I'm looking at a picture of these four young people, and it's just awful. That's about all I could say about it. Can you imagine a more awful experience for a parent or a grandparent? I can't.
Yeah, it is really still tough to wrap your head around. So the gag order, this isn't overly new, but I wanted to get both your takes on this. The initial gag order was issued by the Latah County Chief Magistrate on January 4th, and it was extended now to remain in place throughout court proceedings until a verdict has been reached, or unless the mandate is modified by the court. Mark, back to you on this. Are you pleased to see a gag order in place? Your thoughts on this?
Well, I have mixed feelings about this. I'm a First Amendment guy. I believe the public has a right to know. I believe people have a right to speak. But you made a point in the very beginning of this podcast that a criminal suspect, and that's all Mr. Kohberger is a suspect, is innocent until proven guilty, and that's a almost a forgotten constitutional privilege in the online. Everything is on the internet era, where amateur sleuths like me stick their nose in things and declare people guilty or innocent before any jury gets a chance to look at things. So the idea that a judge issues a gag order in a situation like this is probably, at least from a criminal defense standpoint, Jessica can probably speak to this better than I can, especially in Idaho, where the news must be 24/7, is probably appropriate from a criminal defense standpoint.
And Jessica, the court of public opinion, as Mark just alluded to, is really ubiquitous. You can't escape it with social media and the internet. Can you kind of explain, since you are in Idaho, why they issued a gag order, the purpose of it, and also if you agree that it should stay in place through the reading of the verdict?
I do think it should stay in place, especially in a case like this, which has gotten so much attention from the beginning. The reason is because a trial is such a controlled environment. The rules of evidence, that go back hundreds of years in their creation, are all there for a reason. And all these complicated concepts like character evidence and when we should consider character evidence and things that we control in a trial for various reasons of prejudice and the jury maybe taking something the wrong way and applying too much significance to it. All of those things would be completely eroded if we have the ability for the public to take apart every bit of information that they're given, analyze it ahead of time, without the ability of the courtroom to sort of control how that information is handled. So I think what was happening in this case in the beginning, you were seeing, certainly from the public defender out in Pennsylvania, who started making comments about his client communications, things that were being said. Law enforcement was saying he said something when they were first arrested about somebody else being involved. All these things that you may not want this information coming in a trial, whether you're coming from the prosecution or the defense, for 100 different reasons. But that information was getting out there to the public, who is going to be the jury. So ultimately, it was like throwing out the window the whole process of a trial and all of these rules that are in place to make that trial fair. So I think when those things were happening, the judge in Idaho said to herself, I need to preserve the fair trial concept here. And the only way to do that is to prevent people from going to the media and discussing bits of information that the public can then take how they want to take it, and pick it apart and write about it. Because now we have blogs, we have, all of these TikToks being made about it. Everybody was just posting so many different perspectives and thoughts, and this was just had the potential to bias people too quickly.
Joel, the other side of that, Joel, is if you don't have a gag order and you do release stuff to the public, at least you're releasing the actual evidence. And what we're experiencing now is leaks and rhetoric and outright bullshit that is being released on the internet. People's opinions as to what somebody did or where somebody was or what a piece of evidence means, rather than actual facts. So the counter argument would be, if you're not going to have a gag order, you would actually get accurate information being released to the public rather than rumor and innuendo. Having said that, I agree with Jessica, and I made the point earlier that I think in a case like this, a gag order is probably appropriate. Very hard to enforce when you're dealing with people who find things on the internet that interest them, and all of a sudden it becomes news. And I put quotes around the word news.
Yeah. I mean, interesting case to be made on both sides. I can tell you the media won't love the gag order because it gets increasingly harder to run stories about what is the biggest murder case, arguably, of our time. There is yet more news concerning this horrific quadruple homicide in Moscow, Idaho, and we are finding out from a program called The Eyes of a Killer Part 2, produced by Airmail. I'm not sure if this is a podcast or a television show, but kudos to them for getting this news. And they are reporting through multiple law enforcement sources that once law enforcement started to surveil Bryan Kohberger, he vanished for hours, and we don't know. According to this program, he slipped the net almost as soon as the white Hyundai Elantra pulled out of the parking lot at his graduate housing complex in Pullman, Washington. And this is after he became a person of interest on the morning. He became a person of interest before this, but the slip happened the morning of December 13th. Of course, the heinous murders happened November 13th. So it was exactly 4 weeks to the day from when it happened. Jessica, to you, how troubling is it to learn now that law enforcement lost their suspect?
Well, I guess it depends on what they were surveying at the time and what information may have been gathered during that time period. And I guess at some point they'll release an actual timeline of his actions while they had him under surveillance. And I thought that descriptions of what we heard of his activities in Pennsylvania were really interesting. Because when they had him under surveillance, and they indicated that at some point he was cleaning the car vigorously, he was taking trash out with gloves and putting it into the neighbor's trash, things like that. Observations that were being made, those observations can be very important. And those, I guess, what we don't know is, was that a time period where he realized that he was potentially on their radar? Was this a time period where he knew that the white car, because I think that's what originally he was the most worried about, right? I mean, if we're assuming if this was him, in fact, and he got in this car and he traveled across the country in that car, the car was the only thing really being publicized. So did he know that he was potentially going to be under their radar at that point in time? And if so, could that have been a time period where he was able to get rid of certain things that may have been hidden? We still don't know what happened to the weapon or things like that. I mean, we just don't know. I think what I would be interested in seeing is that timeline and exactly what their observations were, both before they lost him and right after they lost him.
And speaking of not having the murder weapon, that knife, he took a circuitous route. We'll get to that in just a moment. But Mark, to you, law enforcement reportedly had to scour ALPRs, which I'd never heard of until researching this, which are automated license plate readers, trying to find the car in nearby states. What's interesting, to Jessica's point, they were traveling. They ended up getting pinged. The car was pinged in Loma, Colorado, eventually. That was 900 miles away from Pullman. Roughly a 15-hour drive from Pullman to Loma. So we've got to presume from that he was missing or went off their, quote, radar for about 15 hours. But what we find out then is it was, in fact, not the most direct journey. It's something that reportedly came at Mr. Kohberger, not the father, but Bryan Kohberger's assistance, and for a still unknown reason. According to the source, Kohberger claimed there would be wintry conditions along that route, and they should instead travel south towards Colorado, a route that added roughly 6 or 7 hours to the journey. What do you make of that? Do you think he was trying to either evade law enforcement or take a circuitous route where maybe he could dump the murder weapon while he was traveling, ironically, with his own dad? But something smells a little fishy. What are your thoughts?
Well, Joel, anything I say about that would be wildly speculative. Here's what I will say, and again, to our point previously about gag orders and such. While Jessica and I are both attorneys and experienced ones at that, I'll remind you again that the guy is a suspect, and only a suspect. He's innocent as of right now. But let's assume, just for the sake of discussion, and Jessica didn't touch on this, and I think it's the most important aspect of this. Let's assume he's guilty for a second. I don't know about you guys, but the fact that the FBI and the local police lost the guy for 15 hours thinking that he's a murderer scares the shit out of me. What if he had committed another murder on his way to Pennsylvania? What I really think, if to answer your question, is I think he was running home to mommy. I think he needed to be around family members, and that's what he was intending to do. The other question is whether or not he knew that he was an object of police interest at the time he got in the car and drove to Pennsylvania. I'm not sure he did. So I'm not sure there's anything nefarious about him getting in the car and going home. As to how he got there, whether he, went around the mountains or through the mountains or over the valley and through the woods, I really can't comment on that, but I would say that he was clearly heading to Pennsylvania. He contacted his dad, who ended up in the car with him, as is evidenced by that video from Indianapolis or Indiana somewhere. And I don't think there's anything at all to this other than he wanted to go home to Pennsylvania. Guilty
And there
or
was
not.
some, speaking about those Indiana stops, they're in the same story. Originally, there was speculation that the FBI maybe had stopped him intentionally, but now it turns out that the FBI was actually very worried when he was stopped twice in just a matter of moments, knowing who he was, not wanting to interfere with the surveillance. But nevertheless, he was stopped on December 15th, 2 days into their trip, just as I said, just minutes apart, which is kind of a really odd coincidence. But Mark, taking a step back from all of this, I had a thumbnail the other day titled "Stranger Than Fiction" about the Alec Murdaugh trial. What is your process when you're coming up with a story? And please tell the audience, I think you have a book that is loosely based about a crime on a college campus. All the developments that you've heard about this case in Idaho, is it stuff that you would think of, or is this also a case of stranger than fiction?
Well, I'm going to answer that two ways. One, it's a coincidence, a really quirky coincidence, that I wrote and finished a book about an on-campus murder right before an on-campus murder happened, and my book is completely different than the actual facts of this case. In my book, which is not out yet, it's called The Final Steps. It's about a law professor who gets killed on campus on a popular outdoor stairway, which is why it's called The Final Steps. It's not about students getting involved in a mass murder. So I didn't write a shameless book about an actual event that just happened. It's just a coincidence. Having said that, what I typically do, and not in this case, I typically take topics in the news, like a school shooting, or a cop shooting an innocent black man, or the Me Too movement, and I write books about fictional I write fictional versions about those occurrences and how the legal system, both on the criminal side and the civil side, might handle those occurrences. The funny part about this is that the final steps is an exception. It's complete fiction. It's not based on any factual situation. It's simply a cozy mystery whodunit involving a former judge who decides to become a private investigator on behalf of her best friend. So it's kind of interesting, I think, at least, that my normal genre, ripped from the headlines type legal fiction, does not apply to the Idaho murders and the final steps. They're in no way. It's not a rip from the headlines account at all.
Well, back to
the Murdoch situation,
Yeah.
I find very fascinating, and it is absolutely something that I think would make a very fascinating book. A personal injury lawyer of renown. I know a few in the Detroit area. I can probably guess who the Murdoch is in Detroit, and to have a guy like that become the defendant in a family murder would make, and I'm sure Jessica would agree, a compelling fiction. To have it be true, to have it be a factual situation, to have him on trial for the murder of his wife and son, is unfortunate and fascinating at the same time. For an
Right.
author.
Well,
And the
in the
evidence
Alec
in that
Murdoch
case-
trial. I'm sorry. Go ahead,
Yeah.
Jessica.
Oh, sorry. I was just going to jump in. Mark, yeah, and I don't know if you agree, but the evidence in that case so far it also makes it interesting because it's not all that strong from what I've seen. And I haven't been following it moment by moment, but I think that makes it even more interesting because the evidence is just so bizarre in what they've put together as their prosecution so far.
Well, the prosecution is definitely struggling right now. We had some guests on in our last episode to discuss that. But Mark,
think
if
about
I came
the challenge,
to you,
Joel, think about the challenge. Think about the challenge of putting an experienced attorney on trial.
Yes, yeah, it's a lot. But if I came to you and said, I'm going to write a book, and in that book, personal injury attorney kills his wife, his own son. The housekeeper falls down a flight of stairs. The son's friend, who's I forget how old she was at the time, dies in a boat crash. A 19-year-old. I mean, would you say to me, it's too much? Stop. This is ridiculous already.
I would say it's highly fictionalized fiction. It's hard to believe that this actually happened in real life.
And that is why I think the true crime genre has become so interesting to so many. But coming back to Idaho here, the timeline. I went back and revisited the timeline, and it's kind of interesting. We find out, of course, now that in June, Bryan Kohberger arrives to Pullman to start his PhD program in criminology. Already in August, his phone starts pinging near King Road. September, we become aware of this questionnaire where he's now asking ex-cons about their experiences so he can get some information. November 13th, or October, we find out that he's direct messaging the victims on Instagram. And then November 13th, just a few weeks later, these hideous 4 murders happened. Jessica, to you, looking back on it now, we go from June to November. Seems like a very quick timeline for someone to really act on these psychopathic or psychotic or whatever we want to label them as behavior.
Definitely.
What do you think in terms of that progression from June to November?
Well, I mean, it all ties into the other aspects of his personality, right? His criminology degree, the research he had just recently been doing, apparently asking about how victims are chosen, applying to the Pullman Police Department to assist, mentioning the forensics of a rural police department. It's as though before coming to Idaho, or not Idaho, he came to Pullman. Before coming to Pullman, he had at least some sort of concept in mind that out there he was going to perform some sort of criminal act, potentially. And I think one of the pieces of evidence that the prosecutor is going to be laying out in this case, potentially, if they have more evidence that they've accumulated by this time, which they likely do if he really is the person who committed this offense. They've probably put together a lot of information from his computer, from access of cell phone records and things like that, searches. If that all lines up the way that the prosecution expects it to, I think what you're going to see is a picture of an individual who conceived of this notion. Maybe he has done it before. I don't know. I think you've had people who are more experts in that area than I am on your show, speaking about things like that. Whether or not he might have done this before or not, I really don't know. It's not really something that I'm all that versed in, so I can't really speak to that. But it does seem like he had at least in his mind thought about before he came to the Northwest that this was going to be a target area. And you would pick Moscow over Pullman if you were looking for a rural area place to commit some sort of a criminal act like this, because it is more rural in nature. Moscow is more of a small town feel than Pullman does. Even though they're roughly the same in population, they have very different feel, very different environment. Moscow is organically grown as a town, right? It's more of the coffee shops and the restaurants and the shops and the feel of an actual small town. And Pullman, on the other hand, is a much larger university. Washington State's, I think, 30,000 people, as opposed to Idaho, which has about 9,000. And Pullman has more of a metropolitan feel, even though it's not all that much larger. It's not as cute. It's more, I just don't know how to explain it unless you go there and you really look at it. But it's got a totally different vibe. And so I can see why, he would target, if he was looking for rural, Moscow would be more of the target. My feeling is he was targeting a location more than an individual. My feeling is he targeted more of a place to commit a crime, housing. It was dark, the lack of surveillance, the trust of this Idaho town. He took advantage of all of that. And that's what he saw.
Allegedly.
Right. Of course. Yeah. That's what would be if it is him and he is convicted. That's what you're taking advantage of by going to Moscow as opposed to Pullman. You're taking advantage of the trust.
Jessica, can I ask a question?
Yeah.
Is June when he arrived there? Is that his first
I don't know. They said
Pullman?
sometime in summer.
Yeah.
I don't know when exactly.
Yeah, June. He arrived to the campus in June. I don't know.
Because what I understand about June was that's when he purchased the phone that they tracked, and the tracking of this number begins in June. I wasn't aware whether he had been there before or not, and if he had been there before, it might be interesting to find out whether he had another phone that they could track. I don't know, but if he arrived there in June, that makes sense.
Yeah, that is apparently the month he did arrive. And Jessica, I should have asked you this much earlier once you mentioned it. How is your daughter doing? Is she a senior there now?
Junior.
And how is she doing? In the aftermath of all this.
It's. I think she's handling it well. I think her friends are handling it well. Things are definitely different. I mean, there's no doubt about that. The fraternity and sorority parties that used to be quite common are no longer happening. Those always had to get permission from the university. They were university sanctioned. And not just the case itself, but I think some of the underage drinking and some of the other things that were brought to national attention, there's just been sort of a change in mentality on what's allowed on campus and sort of the general free sense of that the kids had before. So, I mean, it's kind of like, when she started school, it was COVID. And so there were masks required. Everything was different than your normal college experience anyway when she started her freshman year.
Does
And
anybody walk
it's just
alone on
like
that campus?
intellective trauma, right? What's that?
Does anybody walk alone on that campus anymore? I doubt it.
I think they do. I think they feel more secure than people believe they do. I really
Okay.
do. I think that they believe that this is most likely the individual, and that they are, even though, like I say, when you've been through trauma, it's different. But logically, at the same time, you do believe that it's safe. So, yeah, I mean, I don't know if they walk alone at night. They probably take more precautions in certain ways, but I don't think that they feel quite the fear that other people think they do.
Unsafe.
And did your daughter know Kaylee?
Not well. She was in the same sorority, and it's a small sorority, but she did know her, yes.
Wow. I'm sure they are now locking their doors. Do you think, Jessica, that the university is going to recover, or will it be forever scarred because of this?
I think it will recover. There will always be a difference. Like the president of the university said, we've lost our innocence. He said that early on. I mean, it just makes such an impact at a place where you don't feel like you have to lock your doors, and you don't feel like you have to have your guard up, and you almost feel special. You feel like you get to live in a place where you don't have to worry about certain things that other people have to worry about. And to have that taken from you, you can't ever get that back. So in that way, I think that it's going to be different, but it's still going to be, a wonderful place to be. And I think it's going to end up, moving through this, and these kids are going to get through this together. And I think they're leaning on each other, and they're all, want to be strong and move forward and still love their university. So I think they're going to get through it.
Wow, what an experience. COVID followed by this. If you can get through those two things, you can get through anything, I suppose. So back to this questionnaire for a moment, because when I was revisiting the timeline, I revisited this questionnaire. And basically, this is something that Bryan Kohberger put together. And I'm interested in this from a legal standpoint, Mark, about how the state might use this in the trial. But essentially, Bryan Kohberger put this together while he was a graduate student getting a master's degree at DeSales University in criminology. And he posted it on Reddit, essentially asking ex-cons to participate and share their experiences. He wanted to understand how emotions and psychological traits influence decision-making when committing a crime. I guess if you're a crime writer like yourself, you might put a questionnaire out there to the public, but the case can be made that he's a criminology student. But is this something, in your opinion, that the state will home in on during the trial and say, look, this guy was asking these questions, it points to premeditation of this crime?
If a judge determines it's relevant, I think it can be used against him. It also cuts the other way, though, too. I mean, Stephen King writes pretty gruesome stuff. Does that make him a killer himself? I've written some rather graphic details of a murder. I promise you, I'm a peace-loving, very innocent, wimpy grandfather. There's no crime for having a vivid imagination when it comes to thinking about crime. In a murder case, it's a piece of evidence. Cuts both ways, though. Did he write it because he's a criminology student? or did he write it because he's murdered somebody in the past or was contemplating murdering someone in the future? I'm not, Jessica. You could help. You could probably answer this better than I can. I'm not sure a judge would rule that admissible.
What do you think, Jessica?
I think it's more prejudicial than probative.
Oh, well, yeah, I do think, because you're talking about 404B there, is it more prejudicial than probative? I don't know. If you're looking at intent and you're looking at premeditation and the thought process, I think you can argue it both ways. It would be interesting to see how a judge would come down on that, right? Because I do think it's relevant to some elements of the offense, what his state of mind was and what his premeditation was. And a lot of that comes back, but it's prejudicial, right? Because it's at the same time, yeah, you're talking about, is this a proclivity to commit a crime because you're a criminology student? I mean, it's a fascinating question. I don't know, there have been historically, there have been books, and you're probably familiar with those, about lawyers committing crimes who, people have found that to be a fascinating topic. Criminology student, I mean, that's just right on point. So it's eerie. Yeah.
So another interesting piece of the legal puzzle, I just had Dr. Henry Leon, who is the preeminent forensic scientist in the nation. He worked on the OJ trial, the Jean Bonnet trial, the JFK assassination review, et cetera, et cetera, et cetera. And we talked about the touch DNA on the button of the knife sheath, and he wasn't. He basically, what he said is, the DNA is there, but it's not a timestamp in essence. So it can incriminate to a point, but maybe not fully. And there have been a lot of people who have questioned the legal use of this touch DNA in a trial. So I'm just curious to get both of your perspectives on this. Mark, to you first. You find touch DNA on a button of a knife sheath that was left at the crime. Is the jury going to convict based solely on that piece of evidence, or are you spinning it in a different way?
Well, the way you asked the question solely, I don't think so. I think there's probably going to be a rather large amount of evidence in addition to that may or may not convict him. To Dr. Lee's point, though, the question, as I read reports about the sheath, as they call it, and the presence of DNA on it, is whether or not he had any contact with these students prior to that day, whether he knew them, whether he had visited them previously, if he's not the murderer, whether he was friends with them. And if you look at that and you find a piece of DNA evidence on an object, or they found a footprint that they thought might be his, and it turns out that there are a large number of similar shoes to that footprint. So the fact that it's there and was found on the day of the murder doesn't mean that he touched it or encountered it on that day. So those are things that have to be developed in the evidentiary process before we leap to the conclusion that one little item, which is damning, I'm not going to say it's not, but that one little item is going to convict him all by itself.
Well, to me, it's the placement. Yeah, I think it's the fact that they say that they found it right there beside Madison's body
they did
the
say,
problem.
They did say
it wasn't up in a shelf in the closet, in which case you could say, well, yeah, maybe he sold it to someone, it ended up with them, something that was, somehow it ended up there. I think that the fact that it would be right there puts a timestamp of a sort on it, because I doubt these young women would leave a knife sheath just lying around their room necessarily. I mean,
with Kohberger's family DNA on it.
Right. So
it seems
it's
incriminating to me, but it seems incriminating, but I'm no attorney.
Right, and
The other thing,
potentially they're going to be able to put together the blood of the order of the killings too, right? And so they'll be able to say whether was Madison first, was she last, what was the time frame of this, and does that fit someone discarding a sheath right then and there?
yeah, I did ask Dr. Henry Lee about that as well. He said in a lot of cases they can determine who was killed first, who was killed last, but in some cases you just simply can't tell. He didn't have the evidence or the crime scene photos to be able to even try to make that assessment. He just, as he puts it, he follows the science. Following another bit of legal wrangling in this case, and Jessica, this is more up your alley, I think, with all due respect to the other counselor. And this has to do with Ann Taylor, the public defender from Kootenai County, who was representing Kara Northington, and she is better known as Xana Kernodle's mother. And she was asked by Ashley Banfield on News Nation how she felt about Ann Taylor basically dropping her and taking the Bryan Kohberger case as public defender, withdrawing from Kara's case on the same day that Bryan Kohberger had his first court appearance, which was January 5th. Now, Kara Northington was quoted as saying, "I am heartbroken because I trusted her," meaning Ann Taylor, pretended that she was wanting to help me, and to find out that she's representing him, meaning Bryan Kohberger, I can't even convey how betrayed I feel. Now, this goes with a caveat. A lot of people were upset with Ashley Banfield because it is well known that Kara Northington is a drug user. Many think she is using currently. She's trying to get help. She didn't look great in the interview, so there was talk about exploitation. But I'm just wondering, from a conflict of interest standpoint, should Ann Taylor be handling this Bryan Kohberger case, or is it already being set up for some sort of mistrial?
Well, hopefully it's not being set up for some sort of mistrial.
Jessica,
I don't think she should be handling it. That's my personal opinion. Yeah, go ahead.
Before you answer, is that what he was representing her for, drugs? Because I haven't seen any reports. I heard about
she was representing, for a drug charge. Yes,
a drug charge. Okay, go ahead. I wasn't sure what the
drug charge was. Yeah, well, and I also saw something saying maybe she had a power of attorney over one of the family members or something, which would complicate things even more, in my opinion.
Ann Taylor had the way I understand it, she had power of attorney over Kara. Yeah, that's the way I understand it.
That makes it even more, because a power of attorney gives you access to potentially a lot of information about the person.
And that's pretty troubling.
Yeah, that's troubling to me, more so than the representation of the offense, which, I personally don't think she should be handling it. And I don't know why, after getting the attention, she hasn't, at this point, at least looked into recusing herself. Maybe she has. Maybe she's made some conversations with the state bar and looked into whether or not it's technically a conflict or not, and gotten some sort of a clearance from them. But even so, even if legally you can say it's not technically a conflict, I don't think it's the right thing to do. And as a lawyer, sometimes you make decisions based upon what's the right thing to do as well, or you should. I realize it's a small town. Moscow is a small town. That area, northern Idaho, even Coeur d'Alene is somewhat small. And the county that's about an hour and a half north of Latah County, which is where I think Ann Taylor's from. But Moscow itself, the legal community there is just tiny. And they spend every day together, and they know each other really well.
Yeah, they say that part of the reason that she can't really recuse herself, I think the entire state of Idaho only has 14 death penalty certified public defenders. And in that part of the state, I think it's 2 or 3, and she's one of them. But it's also, Mark, this is the kind of case that could get you a full-time gig as a contributor on CNN. You can write a book. Movie could be made about you. So it's not that easy to recuse yourself, maybe, if you're looking at it from that vantage point, right?
Well, Joel, I'm sure you've had a lot of lawyers on your show, and Jessica would agree with me that there's a difference between impropriety and the appearance of impropriety, and a lawyer ought to avoid both. And the problem with this case, if I was going to say, when you first asked the question, and you asked it of Jessica, not me, I was going to say it depends on the crime. And if she had a traffic ticket, and the woman is a certified criminal defense attorney for death penalty offenses, obviously her ability as a death penalty lawyer precedes her ability as a traffic ticket lawyer. I don't see a conflict in something like that. But if she truly did have access to this woman's personal information, as is described here, if she was truly a fiduciary on a more important case, that it might have been wise to recuse yourself, even if dumping the previous client is enough to avoid the conflict, because you create what we're discussing here now, and that's the appearance of impropriety. And that is kind of my problem with this situation.
For the record, we had Dave Leroy on. He is the former lieutenant governor of the great state of Idaho and also the former attorney general. And we asked him, he said he did not see a conflict of interest as long as the parties were willing to sign waivers, basically consenting to this.
That's always true. you can waive a conflict. That's undeniable.
Well, people said it was his angle is more political. I don't know. I'm not a lawyer and I'm not a politician.
With any waiver, and then could Kohberger say, well, was it voluntary and knowing? And did I have all the facts? And I didn't know that they had discussed the drug house of the mother and, where she had been, or, and so my waiver wasn't voluntary, and then try to get around it that way. I mean, in the law, there are always gray areas. So yeah, the rule does say you can waive the conflict with consent of both parties. But yeah, I still wouldn't recommend it.
The power dynamic is completely different. That's for sure.
So we have the best guests in true crime, but we also have the best audience, STS Nation, as they are known, and they've got some questions for you. We'll take a few, and then we'll wrap this bad boy up. The first one comes from Michael Harvey, and this is right in your wheelhouse here, Mark Bello. Michael writes, hopefully this is, in fact, the guilty defendant. With a public defense, there's literally zero chance for a proper defense. His public defense, I'm sure, goes to Starbucks along with the prosecutor and judge. They all work in the same building day in and day out, and I'm sure they're friends. It's sad, but money plays a very big role in the judicial system and what kind of defense you're going to get. Do you agree with that, Mark?
No. you want
Why?
You want to longer?
Yeah, let's go more than 2 letters.
Well,
yes.
if you were talking about the average, everyday, I handle everything public defender, again, going back to my traffic ticket analysis, but a public defender wouldn't handle a traffic ticket. It's a little more serious than that, but you're talking about a death penalty certified public defender, and I would submit to you that a person like that is a far more experienced attorney than perhaps someone who dabbles in criminal defense and has a great reputation in the community of being a good lawyer in other fields, but takes this case for publicity or something like that. So this woman dedicates her life and her career to these types of cases, And while I agree with you that money plays a factor, and if you mentioned OJ before, OJ had the best defense team money could buy. Is that better? Sure, it is. But this is the probably the best alternative for someone who doesn't have the kind of money OJ has.
Yeah, no, I agree. I mean, you've got the top of the field, right, who are actually really, really great at what they do. Going to cost you probably. There's no one that would do it for this case.
This is no rookie.
Pay that person in Idaho. There's not an Idaho attorney who would take this case who's at the top of the field, right, for $1 million, because you'd have to get rid of the entire caseload for the year.
Yep. And
that would be your only case that you were working on, and you'd have to dedicate yourself and a team and hire that team. That possibility isn't there. So you're right. I mean, of the other private counsel, you've got a mess, right? You've got plenty of people who are going to claim to be criminal defense attorneys who really maybe aren't all that experienced in criminal defense. Maybe they handle a few cases. It takes a lot of experience to get good at criminal defense.
Jessica, you said you knew this woman, right?
I knew Ann Taylor. I did not know Ann Taylor. No, I don't know Ann Taylor. I knew Bill Thompson. I used to work in when I worked as the city prosecutor in Moscow briefly. He was county back then, and that was 20 years ago. And he was great then. He was known as being an amazing prosecutor even back then. But yeah, it was small enough. The legal community was small enough where there's some truth to what your caller said about being in the same circles every day. We would every morning we would meet with the detectives and go through the stops and the arrests of the night before. I knew the judge really well. The few public defenders that were in Moscow, a couple of the best ones are no longer with us. One passed away a few years ago. And so, yeah, we were a real tiny community. Ann Taylor, I don't know Ann Taylor. I think Ann Taylor practices out of Kootenai County, which is where Coeur d'Alene is. That's not where Moscow is, Latah County.
Yeah, she's Kootenai County. Kootenai County.
Yeah. Hey, Joel.
Yeah.
There are two brothers competing against each other in the Super Bowl in a couple of weeks. You think the fact that they're brothers is going to make any difference to the two of them? I don't think so. So I don't. I think too much is being made of this lawyer camaraderie. Right. When you get into the courtroom, you're going to kick each other's ass if you can.
I agree. I don't think that is going to have I don't think that's going to play a part. I don't think she's going to be biased in that sense. I mean, she might be biased in the sense that, well, no, she's not even from Moscow, so she doesn't even have that bias really. But yeah, I think that there's definitely an issue there to be concerned about for sure. But would you hire a subpar private attorney and think you're doing better? Absolutely not. I mean, there's plenty of guys who would take this case and charge some nominal fee and try to get the publicity, and maybe they have a ton of other cases and they don't really know what they're doing. I mean, you could really go wrong that way as well.
And this next comment leads in, Jessica, from Pixie Pancake. If a lawyer is disloyal to a victim's mother, I have no expectation that she'd be loyal to the defendant. Good. You probably don't agree with that. She's going to be faithful to her defendant.
I think I'm a person more than a lawyer in a lot of ways because I tend to agree with people in some of the perspectives that are maybe more humanistic as far as loyalty. Yeah, I mean, I think I don't like it. I don't think she should be on the case, having represented the mother in that capacity. And is it a matter of her not being loyal to this defendant? No, she'll be loyal to this defendant. But do I think it speaks well of her decision-making? Not necessarily.
And then, Jessica, I'm going to toss this one back to you because you're a little more on the inside track here. From Leonard, how many people will be working for the defense?
I don't know. actually, how many people they have on their team, how many investigators. They've probably pulled more than on your average case. So I have no idea how many people they have put together for this team.
And we will round it out right here, Mark Bello, still harping on this issue. From Vicky Weigel, even if the legal issue of conflict of interest does not apply now that Ann Taylor dropped her client, Xana's mom, Taylor is choosing the high-profile case to capitalize on the publicity. It smells bad, not going to lie. Does it smell bad, Mark?
Well, you're making the point I made earlier, and that's the appearance of impropriety. Even if she's resolved the conflict, she's done exactly what the gentleman is saying. She's chosen the high-profile case over the low-profile case, perhaps to enhance her own career, who knows, but she's created an appearance of impropriety, and that's something lawyers shouldn't do. Whether they're per se, quote unquote, ethical or not, as the gentleman says, it smells bad, and lawyers should be avoiding smelling bad. Not a good thing to smell bad.
Idahoan Jessica Bublitz is a skilled litigator, the first woman in Idaho to be named a top 100 trial lawyer. She's also a graduate of the University of Idaho College of Law. Her daughter is presently at the University of Idaho with close ties to Moscow. Jessica, question for you to round things out and your final thoughts, but something that keeps coming up, and I, again, am not a lawyer. There's talk about the prosecutors convening a grand jury so that they don't have to wait for the next case hearing, which is June 26th. Can you explain that briefly and tell us what you think is next in all of this?
I think it depends on how strong the evidence is right now. There were 1,000 pages of documents disclosed, and both sides, or the defense is certainly pouring through that right now. There may be additional disclosures to come. I think if that evidence is really, really strong, then one thing the defense might consider is trying to get some sort of a plea deal for a life sentence as opposed to a death. And I don't know what the considerations are from the state on that. I don't know where they are on that. If this is a death penalty or nothing case for them, they're going to be taking into account the victims' perspectives on that. They're going to be taking into account all kinds of factors when making that decision on are they willing to come off the table of a death penalty or not. And one of those is the risk of not succeeding with the death penalty, even if you get the conviction. And so there are going to be those considerations. And then they can get that grand jury indictment either before or after they start those negotiations and those talks. They can do that anytime. So they have until June to convene that secret grand jury of people and present to them the evidence they have and get that probable cause stamp. But as soon as they do that, it moves forward into the district court and you would plead not guilty and get your trial date set. So the ball really starts rolling at that point. So what they have right now for both sides is some time to look at the evidence and think about negotiations and where they want this case to go. And so a lot of when they decide to move to the next step is going to depend on those factors.
As an attorney and civil justice advocate, author Mark M. Bello draws upon 40 years of courtroom experience in his Zachary Blake legal thriller series. He's gone from lawyer to crime and legal thriller author. He's also the host of Justice Counts podcast. Mark, your final thoughts about all this?
Well, I want to comment a little bit on the last question. Just like a probable cause hearing, getting an indictment from grand jury requires very little evidence. It's just Jessica, correct me if I'm wrong, but it's a preponderance, isn't it?
It's actually not a preponderance.
It's even less.
Substantial evidence on each element of the offense, and that's one thing that the magistrate did not read correctly in the original hearing. But she said more likely than not, it's not. It's substantial evidence on each element, but substantial evidence is not much at all. in the law.
It doesn't require the burden of proof that is required to
No.
convict a person in a criminal.
Well, no, and that's the thing. There's
trial.
no weighing at all. There's no weighing at all. There's no preponderance. There's no evidence from the other side necessary. All the state has to do is show some evidence on each element, and they've got
the one I was involved in. All you had to do was show up, and you'd get an indictment.
That's what they say. You can indict a ham sandwich, right?
Exactly. So
Yeah.
I wouldn't take the idea that there's a grand jury decision to go forward with any big deal. To your final thoughts question, I caution everybody to let the process play out. Increasingly, as a guy who's been in the system for almost 50 years, I see people convicted in the news, convicted in the press, convicted on the internet. Let the process play out and let the prosecution prove this guy guilty. Excuse me. I understand what the reports say, and I understand what the timeline shows, and I understand there's evidence of his guilt, just as there is in the Murdaugh trial of Murdaugh's guilt. But it's the prosecution's burden to prove guilt in court. And until that happens, the Constitution says we're innocent. And more, I'm seeing people convicted in the news. And that's a scary thought for me.
Keep it in the actual courtroom, not the court of public opinion. Thanks to both of you. Final quick programming note, we'll be continuing our Alec Murdaugh coverage all week, every week through the end of the trial. And this Friday, another live episode of your True Crime, Phil and Gil. Love you, America. Till next time.